Congress cannot check the pardon power. The courts cannot check the pardon power. If the president chooses to exercise his Article 2 authority to pardon someone, there's not a damn thing Congress or the courts can do about it. And if they passed a law to do something about it, if Congress passed the pardon statute and said the president can only issue 5 pardons a year, that would be an unconstitutional separation of powers violation because the Constitution does not grant Congress the right to step into the pardon power. Here, there's nothing in the Constitution that grants Congress the authority to impair the Article 2 president's ability to fire people. There is a provision to impair the Article 2 president's ability to hire people. If the president wants to hire a cabinet member, the Constitution says he has to get the advice and consent of the Senate. That is the constraint on Article 2 power by the Article 1 legislative branch, but it's spelled out in the Constitution. So it's not a separation of powers violation for the Senate to do that. It's a explicit enumerated checks and balances. But if Congress tries to do something like that without explicit constitutional authority, as they are doing here with the Inspector General's Act, impairing the president's ability to fire subordinates without any constitutional provision that allows for that, that is an obvious separation of powers violation. So it is not a close call under the best of circumstances. It's a very easy call. An unelected black-robed tyrannical inferior district trial court judge, Anna Reyes, no stranger to Trump, out of the infamous District of Columbia Federal District, has much to her regret had to rule that Trump was legally justified in his firing of 11, really 20, but 11 sued, 11 inspector generals from government service. It doesn't really matter what an inspector general does. It's just a governmental official. Supposedly, you can think of them as government watchdogs, but really these are just government hack positions that are given out to friends and family of whoever's in power that answers to Trump. And he decided he wanted to fire all these people. He did. They sued. And the matter ended up before Judge Anna Reyes. Again, no friend of Trump's. And she's clearly chewing on lemons as she writes this for her bitter, but legally sound, constitutionally sound decision favoring Trump. Judge Anna Reyes has experience with Trump before. In the context of these lawfare cases, she caught the case about the transgender military bans. So on January 27th, a week or so after he was sworn in, Trump issued an executive order saying that trans-confused people cannot serve in the military, transgender identity being incompatible with military standards of readiness, cohesion, and integrity. A bunch of them sued. The case ended up in the courtroom of Judge Reyes a couple days after the executive order. Now, in the case of Anna Reyes, she did issue an injunction against him. So she ruled against him. She ruled in favor of the transgenders in the military. Then that was appealed up to the Court of Appeals. Another case she had with Trump was a little more mixed, though. You may remember that some years ago, Trump's tax returns were leaked. Remember that? His IRS tax returns were leaked to the media, and they caught the guy who did that. His name was Littlejohn, Charles E. Littlejohn, and he was federally prosecuted in the courtroom of Judge Anna Reyes. Now, this was before Trump was reelected. This was January of 2024. So Judge Reyes may have been expecting Kamala Harris to win. She didn't know Trump was going to be president again. But in any case, in the trial of this IRS agent or contractor, Littlejohn, who leaked Trump's tax releases, the federal guidelines recommended 4 to 10 months for that crime of leaking Trump's tax returns. And she sentenced them to 5 years, a multiple of what the federal guidelines called for, characterizing his leaking of the Trump tax returns as an attack on our constitutional democracy. So that could possibly be seen as a pro-Trump position. She is a Biden appointee, by the way. Let me grab my red pen. Of course, When they don't like what they have to write, judges like to get into little history lessons. On May 28, 1972, U.S. Senators George McGovern and Hubert Humphrey, two men running to be the Democrat Party presidential nominee, made last-minute preparations for their first televised debate later that evening. The man they hoped to replace, Richard Nixon, was halfway around the world in Russia. That day, he became the first American president to speak directly to the Soviet people. Okay? From the Kremlin. While the senators debated and the president spoke, a few men... Oh, it's a Watergate reference. Ha 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 ha! Of course it is. While the senators debated and the president spoke, a few men broke into the headquarters of the Democrat National Committee at the Watergate complex in Washington, D.C. They copied documents, planted listening devices. Weeks later, they broke in again. This time, police apprehended them before they escaped. Two Washington Post reporters began digging. Had the men acted on behalf of Nixon, the Nixon administration falsely claimed ignorance, and the rest, they say, is history. A president resigning in disgrace, a public insistent on change, and a legislature scrambling to shore up public trust. After Watergate in 1978, Congress enacted the Inspector General Act. The act created an Office of Inspector General, OIG, led by an Inspector General in each of several federal agencies to combat bureaucratic waste, fraud, and abuse. Congress required that each Inspector General be appointed without regard to political affiliation and solely on the basis of integrity and demonstrated ability. Like, how would this happen? The whole government is a political operation. There's no apolitical people in government. So how would they be appointed without political affiliation? It's obviously nonsense. The act gave Inspector Generals the broad mandate to promote economy, efficiency, and effectiveness, and prevent and detect fraud and abuse. Congress required that the Inspector Generals keep Congress fully and currently informed about problems and deficiency in the administration of programs and operations. Does anybody see a problem already? Who do these people work for? Fast forward about 4 decades. May 15th, 2020, President Trump fired 2 Inspector Generals for loss of confidence. So that's not today. That was his first term. As the Inspector General Act requires, back in 2020, Trump provided Congress with 30 days notice of those terminations because 2 of the Inspector Generals President Trump fired handled issues related to his first impeachment. A group of senators asked for the reasons for the terminations. Trump provided none. In response, Congress enacted the Securing Inspector General Independence Act, which requires the president to provide Congress the substantive rationale for an inspector general's removal. That brings us finally to today. On January 24th, 2025, 4 days into his second term, President Trump fired many inspector generals, 20 of them. He did not first notify Congress, as the Inspector General Act requires, and he did not provide any rationale, as the 2020 amendment to that act required, much less a substantive rationale containing detailed case-specific reasons for the firing. He just said they were fired, period. The plaintiffs, the people suing in this case, 8 of those 20 fired inspector generals sued Trump, alleging that Trump violated the Inspector General Act by failing to provide the required notice and rationale, 30 days notice and a specific rationale. They seek, along with back pay and benefits, to be reinstated in their positions, pending the president's compliance with the Inspector General Act. Now, remember, this has been the tension in these firing cases from the beginning. The only remedy is money. The remedy cannot be in our constitutional order. The remedy cannot be that Congress creates a law and the courts enforce a law. Article 1 Congress creates a law and the Article 3 courts enforce a law that compels the Article 2 president to delegate his executive authority against his will. Humphreys does not hold for that. Weiner doesn't hold for that. Humphreys-Weiner doesn't hold for that. I think Humphreys and Weiner are bad law, but the most they give you if you've been wrongfully terminated by the president is back pay. What these people, these inspector generals, and what everyone else who's been suing Trump because he fired them this year has wanted is not just money. If all they wanted was money, it wouldn't be that big a deal. What they want is money and the job back. They want the delegation of executive authority against Trump's will. In a couple of these cases, while these firings were working their way through the federal courts, these people actually were put back into their offices by the courts. And you know what happened the moment they were back in their offices? They started issuing orders that were contrary to those of the President of the United States. Obviously, that cannot be allowed to exist. There can only be one person who's president issuing orders. They can't be countermanded by his subordinates, or his subordinates would be superiors. So these inspector generals, like everybody else, wanted back pay and benefits and to be reinstated to their positions, to force Trump to delegate his executive authority against his will. Trump countered that the IGA, the Inspector General Act, is an unconstitutional intrusion into the president's removal powers under Article 2 of the U.S. Constitution. I think it's pretty clear that's the case. In any event, they argue, being denied the opportunity to serve out the 30-day notice is not irreparable harm. This is Trump arguing. Look, if I violated any rule, it was the 30-day notice rule. So what difference would it make? We would just wait out the 30 days and then they're fired? Why would we put them back in their office for that? Judge Reyes says President Trump violated the Inspector General Act. That much is obvious. Well, sure. So Congress created a law and Trump violated that law. He did not give the 30 days notice the law requires. But is the law constitutional? If Trump violated an unconstitutional law, that's no legal offense. So Trump violated the Congressional Act, and the people suing raised compelling arguments that the violation must be remedied through reinstatement to their positions. In other words, to compel Trump to delegate his executive authority against his will. It is, quoting the plaintiffs here, the people suing, it is decidedly wrong and decidedly contrary to the public interest to have statutory limits designed to provide much needed protection against fraud, waste, and abuse, flouted by the very official constitutionally charged to take care that Congress's laws be faithfully executed. Well, the president is part of his oath is that he will take care that the laws are faithfully executed. But that, of course, means the constitutional laws. Judge Reyes agrees with their argument here. Yes, agreed. It would be against public policy to allow the very person who swears to take care of the laws be faithfully executed to violate the law. But, Judge Reyes says, under well-established case law precedent, that this trial court, unelected black-robed tyrannical inferior district trial court judge is bound to follow, plaintiffs must show irreparable harm. And they cannot, even assuming that the Inspector General Act is constitutional, comports, does not violate Article 2, which it clearly does. The plaintiff's inability to perform their jobs for 30 days, again, the most they would get is 30 days notice, is not irreparable harm. Why is it not irreparable harm? Well, wrongful terminations are really never irreparable harm because they can always be made up for with money. If they can be made up with money, it's not irreparable. You're repairing it with the money. Moreover, if the inspector generals were reinstated, the president could lawfully remove them after 30 days by providing notice and a rationale to Congress. Unable to reinstate the plaintiffs to their position, the court denies the plaintiff's motion for a permanent injunction. And now the judge waxes on poetically about how wonderful these government hacks are. She writes, these plaintiffs, these inspector generals, these government hacks have devoted their careers to public service. Together, they have served our country for over 250 years. She's adding up all 8 of these inspector generals. She's adding up how long they've been at the public trough, getting rich federal salaries and benefits. They served our country for over 250. Why would this be relevant to any legal question in this case? Is there anything about the statute that says it's triggered if the collective tenure of the government officials is 200 years or more? This is just the Judge Anna Reyes being emotional. Together, they served our country for over 250 years, have won innumerable awards. Well, what's that got to do with anything? While this unelected black-robed tyrannical inferior district trial court judge Anna Reyes cannot order them reinstated, it can give them the recognition their decades of government service demands, not even deserves, demands. All two brief summaries of their work follow here to emphasize their contributions. This recognition is no doubt of little comfort to them now. The historical record, however, reflect the unbiased contributions, experience, and skills of the government officials President Trump dismissed without explanation. The only legal question is, does he have the authority to do that? All the rest of this is just trying to make Trump look bad for exercising his legal authority. Now she's going to go through each of these people. I'm not going to read all of this. 1, 2, 3. These are all government hacks. 4, 5, 6, 7. Did I miss one? Oh, 8. Here we go. So these are the 8 inspector generals. And she just goes on about how wonderful they are and how long they've served the government and all the sacrifices they've made it. These were all people who were very well paid for their years of service with very rich federal benefits and pensions, folks. Don't feel too sorry for them. The defendants, Trump, also raises a constitutional question. This is the separation of powers question. Does Congress have the right to limit? Does the Article 1 Congress have the right to limit the Article 2 president's power to fire subordinates? Judge Reyes says this is a close call under the best of circumstances. No, it is not. It is not a close call. So we have separation of powers, Article 1 legislative, Article 2 executive, Article 3 judicial, and we have checks and balances. I'm sure you've all heard that phrase. Checks and balances are places where one branch of government can constrain another branch of government. For example, the president cannot appoint any officers, any principal officers he wants. If he wants to appoint a principal officer like a cabinet member, he has to nominate that person to the Senate, and the Senate has to vote to confirm. They're only a principal officer at the president's request with the advice and consent of the Senate. That constraint of the Article 2 power by the Congress is not a violation of the Separation of Powers Act because the Constitution specifically gives the Senate the authority to do that. So something that would otherwise be a separation of powers violation is instead understood to be a proper checks and balances if the Constitution spells it out as a checks and balances. Where the Constitution gives the Article 2 president a power and does not explicitly provide in the Constitution a means to check that power, any effort to check that power by another branch would be a violation of the Separation of Powers Act. So, in the nomination of principal officers, the Constitution has a check by the Senate on the president, written right there in the Constitution. That's a checks and balances provision, not a separation of powers violation. But when it comes to things like the president's pardon power, Article 2 says the president has the power of the pardon. Nowhere in the Constitution is there any check on that power. Congress cannot check the pardon power. The courts cannot check the pardon power. If the president chooses to exercise his Article 2 authority to pardon someone, there's not a damn thing Congress or the courts can do about it. And if they passed a law to do something about it, if Congress passed the pardon statute and said the president can only issue 5 pardons a year, that would be an unconstitutional separation of powers violation because the Constitution does not grant Congress the right to step into the pardon power. Here, there's nothing in the Constitution that grants Congress the authority to impair the Article 2 president's ability to fire people. There is a provision to impair the Article 2 president's ability to hire people. If the president wants to hire a cabinet member, the Constitution says he has to get the advice and consent of the Senate. That is the constraint on Article 2 power by the Article 1 legislative branch, but it's spelled out in the Constitution. So it's not a separation of powers violation for the Senate to do that. It's a explicit enumerated checks and balance. But if Congress tries to do something like that without explicit constitutional authority, as they are doing here with the Inspector General's Act, impairing the president's ability to fire subordinates without any constitutional provision that allows for that, that is an obvious Separation of powers violation. So it is not a close call under the best of circumstances. It's a very easy call. So in every one of these firing cases where Trump fires someone in violation of congressional protection, and they sue saying Trump violated the congressional protection, the Supreme Court has upheld Trump. This whole model of these inspector generals is not created in the Constitution and therefore is a separation of powers violation. This court of Anna Reyes says the combined balance of hardship and public interest favors the plaintiffs, the people suing, not Trump, but not by much. So she thinks the Congress public interest created by statute carries more weight than the constitutional interest of the Article 2 executive branch. This is someone who should not be a federal judge, my friends. Conclusion. The court, the unelected black-robed tyrannical inferior district trial court of Judge Anna Reyes, recognizes the plaintiffs' exceptional service as inspector generals, marked by decades of distinguished leadership across multiple administrations. Look how long these hacks have been in these jobs. They sacrificed much to take on the role of an inspector general and its many demands, no doubt including substantial time away from family and far larger paychecks available in the private sector. Anybody believe that? They deserved better from their government. They deserved better, and they still do. Unfortunately, this court of Judge Anna Reyes cannot provide the plaintiffs with that more. Their theory of harm fails to establish they've suffered in a legal sense, which is the only sense that should matter to a judge. What is she trying to imply? A moral sense? The theory of harm fails to establish they suffered in a legal sense an irreparable injury that cannot be compensated with remedies available at law, meaning money. In general, a movement's failure to show irreparable harm is grounds for refusing the injunction. Accordingly, the court here denies these former inspector generals' motion for a preliminary injunction and motion for a permanent injunction. This court will not decide the merits of the plaintiffs' claims and whether they are entitled to legal remedies such as back pay at this time. Due to the Supreme Court's recent grant of certiorari in Trump v. Slaughter, this court's going to wait on the question of back pay. So the whole Trump v. Slaughter case, the Supreme Court's going to revisit Humphrey's executor. And the Supreme Court will either say Humphrey's executor is overturned, or they're going to say Humphrey's executor must be understood to allow only for the remedy of back pay, not the remedy of reinstatement. Now, I think the proper thing for the Supreme Court to do is overturn Humphrey's executor. Remember, Humphrey's executor did two things, and so did Weiner and Humphrey's Weiner. It said the president can be held liable for wrongfully terminating a principal officer of the Article 2 executive branch. I think that's bad law. I think that's obviously unconstitutional. So, given that's the central holding of Humphrey's should be reversed. But we have a Chief Justice, John Roberts, who, if you give him a way to half-ass a decision, he'll choose that way every time. And the half-ass decision would be to say, we're not going to overturn Humphrey's. We're going to clarify, however, that even when you follow Humphrey's, all you get is money. You don't get to compel the president to delegate authority against his will, which would probably be enough of a win for Trump. He doesn't really care if these people get back pay. He just does not want people he doesn't want exercising his executive authority. That is today's win for Trump, surprisingly, somewhat rarely, at the federal district trial court level, without forcing Trump to appeal it to the Court of Appeals to win, or appeal it all the way to the Supreme Court to win.
You're fired. You're fired. You're fired. You're fired.